Welcome to the N.C.G.S Guide podcast, where defenders of the Constitution assemble to prepare for courtroom battle, and firm owners gather to develop marketing strategies that will revolutionize the practice of criminal defense. Here's your host, the N.C.G.S guy, Jake Minnick.
Hello, fellow freedom fighters, and welcome to episode 160 of the N.C.G.S Guy podcast. On today's episode, we are talking about sentencing. We're going to look at a few sentencing nuances. This is really getting into the minutia of 20-179 and honestly not focusing on the kind of like most important parts of that statute, of the sentencing statute for DWI. The reason for that is that we've already covered some of those bigger topics on the podcast. Go back and listen to episode 31, which was about sentencing factors. In that episode, we kind of talk about the gross aggravating factors, and mitigating factors, and do a deep dive on that. In episode 32, we looked at the sentencing levels, so A1, 1 through 5, and basically ways to mitigate sentencing at each of those levels. What is the maximum sentence? So if you have like a specific sentence level question, go back and listen to that. And then on episode 33, we talked about how to prepare for a sentencing hearing. So if you want a kind of full deep dive into the bigger themes of sentencing, go back and listen to episodes 31, 32, and 33. I think a couple of those episodes, if you watch them on YouTube, maybe even have like a PowerPoint with them. That was back in the early days of the podcast, and so you can go take a look at those episodes if you want kind of the big picture or kind of big issues with sentencing. But today we're going to dive into a little bit more of, again, the minutia when it comes to the sentencing statute. And all of this really comes straight from 20-179. So it's not a, some sort of like aha or lightning rod moment, but it is something that I think these issues come up with enough frequency that they are worth at least being aware of and potentially using on a regular basis. So just going to go through a couple of like highlighted points of the sentencing statute. First of all, if you have not read 20-179 in full, take 15 minutes at some point and sit down and read the sentencing statute. If you do DWI cases regularly, this is something that absolutely comes up in every case, because while you may be taking a case to trial, you need to prepare your client for sentencing. And so to read through the specific DWI sentencing statute in its entirety is really important in terms of understanding how all of the different levels fit together, what is going to be required, who has the burden of proof, aggravating and mitigating factors, all of those things. Just read through it once over, because there is a lot, and it is a very meaty sentencing statute. So go take a look at that. But just diving straight in, 20-179 A1 talks about who has the burden of proving aggravating and mitigating factors. The state bears the burden of proving beyond a reasonable doubt an aggravating factor exists. The defendant bears the burden of proving by a preponderance of the evidence that a mitigating factor exists. Talked about this back on episode 31, but if the state is trying to prove a aggravating factor or a gross aggravating factor, remind the court it is their burden of proof and it must be proved beyond reasonable doubt. I have seen attorneys successfully keep any number of different gross aggravating factors or aggravating factors out of sentencing. And in all honesty, that is as big a win many times as actually attacking the charge would be, because if you can go from a level 2 to a level 5 or from a level A1 to a 1 or a level A1 to a 2 because you're able to attack certain aggravating or gross aggravating factors. Huge victory. So make sure you emphasize that. 20-179A2. Upon request of the defendant, the prosecutor shall furnish the defendant or the defendant's attorney a copy of the defendant's record of traffic convictions at a reasonable time prior to the introduction of the record into evidence. So what does that mean? Well, if the state is asking for certain gross aggravators to be used, the defendant has a reasonable time prior to the introduction of that record into evidence to be furnished a copy if they so request. So that is important for a couple of reasons. One, you should have the opportunity to look at that and review it with your client. But if you've not been furnished a copy and you've asked for it, that could be grounds for a continuance. So if you're scrambling for a grounds for a continuance, and that's not been provided to you, then that could be a very strong, I think, compelling reason for a continuance, because it requires that reasonable time prior, and the day of, minutes before a sentencing hearing is not reasonable time prior to the introduction of that record into evidence. Under 20-79, all within parentheses A1. So we have subsection A that I just went over, and then this is A1, all within parentheses, and then 1 under that. So 20-179, A1, 1. That's where we are. This is using aggravating factors in superior court. So if the defendant appeals to superior court and the state intends to use one or more aggravating factors, then it must provide the defendant with notice of this intent. This is extremely important. So it says in the statute 20-179, the notice shall be provided to the defendant no later than 10 days prior to trial and shall contain a plain and concise factual statement indicating the factor or factors it intends to use under either the GAF section or the aggravating factors section. So basically, if the state wants to use, after the defendant appeals to superior court, a aggravating factor or gross aggravating factor, they have to provide notice of their intent to the defendant at least 10 days prior to trial. This has been examined by the courts, Court of Appeals recently in State v. Hughes, 265 NC App 80, 827 Southeastern 2nd 318, and in State versus Magaha, 851 Southeastern 2nd 659. And in State versus Hughes, the court was pretty straightforward. It said this is pretty black and white in the statute, and the holding in that case was that when the state fails to give notice of its intent to use aggravating sentencing factors as required by 20-179, the trial court's use of those factors into determining a defendant's sentence level is reversible error. Okay, so what does Hughes say? Got to follow the statute. So if the statute is not followed, if the state is not provided that intent, go into a trial in superior court feeling like you are playing with house money. And I have seen this in my practice happen several times by the state, either where they forget to introduce or to provide notice of any aggravating factors. They just don't provide notice, period, when there are some that they could have alleged, or where they provide notice of intent as to some aggravating or gross aggravating factors, but then they leave off other ones. So really pay close attention to that notice of intent. If something is left off, if that is not provided, do not bring that up. Go in and basically be ready to enter a plea if that's the intent in superior court, or take the case to trial without bringing that issue up, because basically under that scenario, the absolute worst sentence that your client could face would be a level 4. If they have forgotten to provide notice of intent or have not timely provided notice of intent of aggravating and gross aggravating factors, the court is not allowed to find on its own in that situation aggravating or gross aggravating factors, and therefore level 4 would be the absolute worst punishment that could be imposed by the court. That's State versus Hughes. State versus Magaha said, while there is a requirement of the state to give notice, that requirement can be waived by the defense. And in Magaha, the court found, yes, in this case, it was waived. These aggravating and gross aggravating factors were presented despite the lack of notice of intent, and the defendant did not object to those priors. I think in Magaha, in fact, there was actual defense stipulation to the prior conviction, as well as a lack of objection during the sentencing. So effectively, this can be waived. So if you are going with that approach of, okay, look, the state has forgotten about this, trial is now started. They can't correct this. If there is any presentation of those factors whatsoever, as defense counsel, object to that coming into evidence, both during trial and in sentencing hearing. Make sure that you do not inadvertently waive that notice requirement that is due under 20-179. Under 20-179 A1-2, this is aggravating factors. The defendant can admit to the existence of an aggravating factor. And so the defendant has the ability to admit a aggravating factor. That might be done for any number of reasons. There is another section of this 20-179 that talks about how that then cannot be presented in evidence if that's the only reason that it was being presented, was to prove a aggravating factor. If the state or if the defendant stipulates to that or admits to that, then the state doesn't get to present evidence of that. But if the defendant does not so admit, only a jury may determine if an aggravating factor is present. So if there is no stipulation, if there is no admission, the defendant doesn't admit that there is a aggravating or gross aggravating factor, then that is absolutely a jury determination outside of what qualifies as a prior conviction, as we see later in 20-179. But all other factors must be determined specifically by a jury. Under 20-179C, when there is a evidence of a prior conviction, whether that conviction exists shall be a matter to be determined by the judge and not the jury in district or superior court. So again, if it's prior conviction, then that is a judicial determination, not a jury determination. Hey, podcast listeners, I want to briefly interrupt today's episode to invite you to join me at the inaugural Freedom Fighter Summit in Asheville this October. This in-person only event is designed for growth-minded lawyers determined to take their criminal defense practice to the next level. Due to the size of the summit's venue, there are a limited number of seats available. Don't miss out on the incredible lineup of speakers and spectacular networking opportunity that this summit provides. For more details, visit www.miniclaw.com/summit. Enter the promo code N.C.G.S, guy, all lowercase, all one word, at checkout for $150 off your summit ticket. Look forward to seeing you there. Now back to the show. 20-179D. This is under the aggravating factors to be weighed. Again, I did a whole podcast episode number 31 on this GAFs, aggravating factors and mitigating factors, but just wanted to point one out specifically. So this is under 20-179D7. One of the aggravating factors listed is that there is a conviction under 20-141 of speeding by the defendant at least 30 miles per hour over the speed limit. So the way that I read that, a particular aggravating factor is that there doesn't just have to be an allegation that there was a speed of that specific kind of speed level. So it's not just that there was a conviction for that particular speed, but that there was a or an allegation, I'm sorry, of the defendant going 30 miles an hour over, but there actually has to be a conviction. So where this might come up is, and this is true actually for 20-179D6 as well, where there's an allegation of speeding by the defendant in order to elude arrest. But just because the factual scenario or the basis for the stop is speeding, and the speed according to the officer is 30 plus. So let's just give as an example, the speed limit is 50 and the officer clocks and estimates speed at 90 miles an hour. If the defendant is not charged with speeding, then this does not become a GAF. The GAF is conviction under 20-141 of speeding by the defendant by at least 30 miles per hour over the legal limit. So it's the conviction, not the factual scenario that mandates this GAF. Furthermore, let's say that in that scenario, client is charged with DWI and going 90 in a 50. If the speeding ticket is dismissed in exchange for a plea on the DWI, again, there is no aggravating factor. It's the conviction that triggers the aggravating factor, not the charge or not the factual scenario. So again, it's not enough for the reality of the situation to be that your client was going 30 miles per hour over. It's not enough that there was an actual charge for that. There has to be a conviction in order for that aggravating factor to be alleged at sentencing. Also, kind of practical note on this front, there have been a number of times where I have had a client that the state will not dismiss the speed, will not dismiss the DWI, but I have had a number of times where I've asked the DA and the court, along with the DA's consent, to basically use that aggravating factor in the DWI sentence and then to arrest judgment on the speeding charge, to arrest judgment on the speed itself. And in a lot of situations, then you can avoid multiple 1-year suspensions, or at least multiple suspensions, one for DWI and one for speeding with the DMV, and therefore keep your client open to a limited driving privilege on just the DWI charge. So a lot of speeding tickets where there is speeding 16 plus over the speed limit are going, or 15 plus over the speed limit, are going to trigger a separate suspension for speeding, which thereby may keep your client ineligible from getting a limited privilege on the DWI if they're otherwise able to get one, level 3, 4, 5, and otherwise eligible for a limited privilege. So that might be one means of trying to avoid those two suspensions from going into effect, so that you can request a limited driving privilege on the DWI charge. So skipping down a good ways, this is just kind of minor point, but something that I feel like sometimes judges are scratching their heads over, or defense attorneys are scratching their heads over. Under 20-179 F2, 2 or more impaired driving charges may not be consolidated for judgment. 2 or more impaired driving charges may not be consolidated for judgment. So you cannot consolidate multiple DWI convictions. Skipping down again, to 20-179P. If you have never got that far down in the sentencing statute, again, read the full sentencing statute, because you don't hear 20-179P talked about very frequently. But this is a section called Limit on Amelioration of Punishment. And so for active terms of imprisonment imposed, the judge may not give credit to the defendant for the first 24 hours of time spent in incarceration pending trial. So again, this is generally common knowledge, but it's sometimes may be helpful to know where in the sentencing statute this comes from. The defendant on a DWI conviction cannot get credit under an active term of sentence for the first 24 hours of time spent in incarceration pending trial. Secondarily, for under 20-179P2, the defendant shall serve the mandatory minimum period of imprisonment, and good or gain time credit may not be used to reduce that mandatory minimum period. So, again, on a level 1 through 5, not A1. So we're going to leave A1 out of the equation, but level 1 through 5 on an active sentence, you can typically see the good time or gain time be applied, where you're basically getting 2 days credit for every 1 day served. What 20-179P2 says is that you cannot get gain time for the mandatory minimum period. So what does that mean? Well, if you have a level 1 client that is sentenced to an active sentence, not a probationary sentence, but an active sentence, let's say of 30 days, somehow you're able to convince the court that the mandatory minimum is to be applied, they're going to serve 30 days. They're not serving 15 days in that scenario. So I don't think that this, again, gets triggered very often. But again, if for some reason your client would serve less than the mandatory minimum, if good time or gain time were applied, then that's not going to work, because they have to serve the mandatory minimum under the level 1 to 5 framework. And again, good or gain time doesn't apply to the A1 sentence. Finally, this is a place where I think that there is a lot of confusion. 20-179R. So if you have a level 3 to 5 client, this is something that I think has come up a couple of times on my own end, and I've heard it several times from other attorneys, either at the office or in the bar, and that is where probation can be required in a level 3 to 5 sentence. I think there are some times when we get caught off guard with a probationary sentence on a level 3 to 5. And generally speaking, it's pretty difficult under the sentencing statute to impose a probationary sentence at this point. And by probationary, I mean a supervised probationary sentence, not a probationary sentence, but supervised probationary sentence. The default is strongly in unsupervised probation. So if you just have a judge that is, wanting to impose a supervised probationary sentence on your client, there are some real limitations on that now under 20-179. So here's 20-179R. Unless a judge in the judge's discretion determines that supervised probation is necessary. So first of all, judge must determine that supervised probation is necessary and includes in the record that the judge has received evidence and finds as a fact that supervised probation is necessary. That's where most of the time you just don't see the finding in district court. You just hear the judge say, after a level 3, I'm posing a level 3 punishment, 6-month sentence, that sentence to be suspended. The defendant is placed on supervised probation for a period of 24 months, whatever it might be. So they'll say that defendant is placed on supervised probation, but again, there must be evidence received and a finding of fact that supervised probation is necessary, and states in the judgment that supervised probation is necessary. So again, three things that the judge must find. First, the judge must determine that supervised probation is necessary. Okay, they do that in every situation where it's ordered. Secondly, they must include in the record that the judge has received evidence and find as a fact that supervised probation is necessary. And then third, the judgment itself must state that supervised probation is necessary. So you have to have those three things by the court. And in district court, you generally don't see that in a lot of cases, even the received evidence, but certainly a finding of fact about supervised probation being necessary, or a note in the judgment that supervised probation is necessary. The defendant shall be placed on unsupervised probation if the defendant meets three conditions. So the conditions that would kind of like almost mandate a unsupervised probationary sentence are: one, that your client has not been convicted of a DWI within 7 years. Two, and this is almost like corresponding, that they're either a level 3, 4, or 5 sentence. And then three, that they've obtained a necessary substance abuse assessment and completed any recommended treatment or training program. So if you want to help your client guarantee, or at least very, very strongly guarantee, or suggest that they should not be placed on supervised probation, make sure that your client has completed an alcohol assessment as well as any recommended treatment prior to trial. That is what triggers this basically super default, I will call it, towards unsupervised over supervised probation. It would really take some, I think, logistical or legal gymnastics in order to find supervised probation by the court under a level 3, 4, 5, given the strong language under 20-179R. So, let's say that in this case, or in a mandated supervised probationary sense, let's say you have a client, there's some maybe bad facts presented. The court says, you know what, this is just, a very heinous level 3 sentence. I am going to find, as a finding of fact that supervised probation is necessary for XYZ reasons. I am notating in the judgment that supervised probation is necessary. So let's say that the judge actually does jump through those hoops and finds both the fact and the conclusion of law that supervised probation is necessary and puts that into the judgment. Does that mean that, let's say the supervised probationary period is 24 months? Does that mean that the supervised probation is going to extend 24 months automatically? Answer is no. So we skip down a little bit to 20-179 or a little bit further down in the paragraph. It says, when a judge determines in accordance with the above procedures that a defendant should be placed on supervised probation, here we go, the judge shall authorize the probation officer to modify the defendant's probation by placing the defendant on unsupervised probation upon the completion of one or more of the following conditions: A, completing community service; B, payment of fines, court costs, and fees, or both. That's it. So effectively, if the judge, again, does go through all of these hoops and finds, okay, I am going to require supervised probation, I'm doing it for 24 months, there also has to be a condition that upon completion of either community service or payment of monies, or both of those things, that the probation officer shall have the ability to transfer it to unsupervised probation. So again, the 20-179R is really something that is very important. If you get kind of blindsided or caught out of left field on a client that's a level 3, 4, 5, you're expecting the normal unsupervised probationary sentence, and all of the sudden, for whatever reason, whatever the facts are that the judge uses, the your client is now looking at a lengthy probationary sentence, this is what you would use in order to avoid that period of supervised probation or argue against that. Final kind of miscellaneous point under 20-179S, method of serving sentence. The judge, in the judge's discretion, may order a term of imprisonment to be served on weekends. So again, the judge is given the discretion to allow the service of a DWI related jail sentence to be served on the weekends. However, it says if the defendant is ordered to a term of 48 hours or more, the defendant shall be required to serve 48 hours continuous of imprisonment to be given credit for time served. So again, basically, you got to serve effectively, 48 hours at a time minimum. If there's only 24 hours left on the sentence, or if it's a level 5, then obviously you don't have to do a minimum of 48. But in order to split up the sentence, you got to do 48 hours at a time. But that does allow the jail time to be served on the weekends. It doesn't specifically say that the jail could be served, on other days. However, again, just practical application of this, I have had clients who, because of their job or because of their family life, whatever it might be, want to serve their time from a Tuesday to a Thursday. Obviously not the weekend, but for whatever reason, this works out better on their schedule. And I have had clients that have served 2 days at a time, basically midweek. So while the language of the sentence talks about the weekends, I've seen judges pretty freely apply that to other times. Basically, midweek, doing midweek sentences. So that is kind of it in terms of miscellaneous sentencing items. Again, go read over 20-179. Make sure that you are aware of the intricacies of that statute. It really is where the bread and butter of a DWI lawyer is in knowing the ins and outs of sentencing. So read through that and then go take a listen again to episodes 31 through 33 for a deeper dive on this topic. If you found the information in this podcast to be valuable, I simply ask that you pay it forward and share this podcast with another member of the legal community. Also, if you would leave us a rating or a review on whatever platform you are listening on, I would greatly appreciate it.